My name is Parna Mehrbani. I'm a partner here at Tonkin Torp. Joining me today is Alex-Jakubiak, an associate in our information security and privacy group. We are scheduled to run for an hour. Our goal is to provide you with a general understanding of the Oregon Consumer Privacy Act, or the OCPA, and how it may affect your business. If you have questions that are unique to your business, we would invite you to reach out to one of us directly or the Tonkin Torp lawyer who you normally work with to discuss your specific situation. We are also happy to answer questions during the webinar. You can submit questions via the Q&A function on Zoom that you can find on your Zoom control panel. It's the black bar at the bottom where you usually go to mute and unmute yourself. So it's the Q&A button. We will do our best to answer every question, but sometimes if the question is very nuanced or specific, it's too nuanced or specific for us to address in this format. And again, we'd welcome you to reach out to one of us afterwards, or if your question does not get answered, or if you have any questions that are unique to your business, you can always contact us. Please try to ask your questions in a general manner without providing any private or confidential information. And if a question with sensitive information is asked, we will politely delete that question, and that's to protect your business. Finally, the necessary disclaimer: the information that we're presenting here is current as of today, June 6, 2024, and it's not intended to be legal advice. Also, we are actively recording today's presentation. So even though you don't appear on video or audio, your name or other identifying information may be captured during the presentation. And by remaining on the call, you are consenting to being recorded. Okay, for today's topic, we are going to take a very brief look at the national landscape of privacy law. And then second, we're going to go into detail about Oregon's newly enacted comprehensive privacy law, the Oregon Consumer Privacy Act. Again, OCPA is the acronym that we use. We'll take a detailed look at the OCPA, when it applies, who is exempted, what rights consumers have under the law, and then the various obligations many of our clients will be affected by. And then finally, we'll briefly introduce Oregon's new data broker law, which imposes new registration and disclosure requirements on businesses who collect and sell or license data of Oregon residents where you did not obtain the data directly from the Oregon resident. Okay, so what the heck is going on in privacy law? Glad you asked. The short answer is a lot. There's a lot happening. So first, we'll kind of step back for a minute. Back in 2022, there were 5 states: California, which is probably not a big surprise, Utah, Colorado, Virginia, and Connecticut have enacted consumer privacy legislation. Comprehensive consumer privacy legislation is how we refer to it. Everyone else, all the other states, there were some bills that were introduced, many died, didn't go anywhere, a lot of states didn't care. Fast forward today, and we now have 18 and counting. So currently, there are 5 states' laws that are in effect: California, Colorado, Connecticut, Utah, and Virginia. In 2024, we've got 5 more: Florida, Oregon, Tennessee, and Texas. And then that's July 1st, and then Missouri is going to follow on October 1st in 2024. And then in 2025, we've got Delaware, Iowa, Maryland, Minnesota, Nebraska, New Hampshire, New Jersey, and Tennessee. Most of those are, let's see, some of them are January 1st, 2025. New Jersey is January 15th, Tennessee in July 31st, 2025, and then Maryland in October 1, 2025. And then finally in 2026, we've got Indiana and Kentucky. We do expect there to be more privacy bills enacted in 2024. I will say that on and off, there have been different iterations of federal privacy laws, which would probably be easier to deal with because there would be one law that would probably address, would be comprehensive as to what most of the states are doing. There may still be some state outliers that are more restrictive than a federal law, but frankly, I'm not holding my breath for a federal law, but it might still happen. But right now, what we're dealing with is a hodgepodge of state laws. So today we're here to talk about Oregon, which goes into effect July 1. So coming up very soon. The OCPA applies to businesses, including nonprofits, handling the personal data of Oregon residents. You can see on the slide that for nonprofits, the effective date is pushed out one additional year. So it's not until July 1st of 2025 for nonprofits. And there are provisions that are specifically unique to Oregon that are different from a number of the other state laws. Okay, so now we will move to more of the specifics.
So whose data is protected and who are we talking about? We're talking about Oregon residents that your business, including nonprofits, we're just going to probably repeat that because Oregon is unique in applying to nonprofits. Anyone you engage with in context, really all sorts of context except for business to business and employment relationships. Those are two exemptions to the context in which you're collecting data. So this could be direct consumers, indirect, such as if you use like a platform to sell products and you get that data. Potential consumers, job applicants, I mean, everything from general website users to registered, newsletter recipients and survey respondents, anyone that you're interacting with from your business that is not in a business to business capacity or in an employment relationship. And just to be clear about the business to business, this is when you are engaging so with another business directly, and it's for the purpose of a commercial transaction, or maybe you're, talking about how to partner on something, or it's pretty broad. But if we step outside of business to business at all, we should really be considering whether or not this applies.
So these are just to jump in, the business to business is any of your vendors essentially that you do business with, anyone who helps you run your business, and anyone who you interact with that you have a contract with is kind of how you can think about it.
Yeah. There is a threshold applicability that comes in. And so if you don't meet this, the OCPA may not yet apply to you. The threshold is 100,000 residents' personal data in a calendar year, or if you control and process at least 25,000 and you're deriving 25% of your gross worldwide revenue from the sale of such data. And just to be clear, this is looking back at the past year, it's anyone you're holding data, not just who you collected in that year. So you may have collected less than the threshold, but in combination with what you actively are storing, you have hit that 100,000 threshold, which would make this apply. That can be anything from, website IP addresses, email addresses, names. There's all sorts of things that we're going to talk about that could get you up to that threshold. So what data? We're talking about data or anything like around the data that could link back to a person. So if, for example, everyone loves this, age by itself is not personally identifiable, but the second that you put it next to an email address or a name, now it has become wrapped up into the personal data umbrella. So we have to think about, how the data is being stored, and if the way that it's being stored makes it become personally identifiable data, whereas alone maybe it would not have been. The OCPA is unique in that it's calling this personal data instead of personal information, which is what you often hear and what all the other states are currently calling it. And I think this is because Oregon really wanted to recognize that data can go beyond traditional identifiers like names and addresses and include data that, when combined or analyzed, could reveal information about a specific person. This does not include fully de-identified data. That means 100% anonymized, cannot be pieced back together. There's no key that's kept separately, that if you were to look at the key and look at the data, you could put it together. That's called pseudonymized data. This is fully 100% de-identified, falls outside the scope of what we are calling personal data. So examples, the common ones, you've got email address, physical address, geolocation, IDs, date of birth, place of birth. Some other ones that are coming up, biometric information, so like fingerprints. If you have a mobile application, and one of the ways that consumers can enter the application and log in is by using the fingerprint function. That's an example of information that you're collecting on the person. We've got purchase history, internet browsing history, really anything, any sort of data that you're collecting that reasonably we could piece back to a specific Oregon resident, then this law is going to come into play and require you to meet certain obligations in order to collect and use that information as you want. There is a special category of data called sensitive personal data. Many states have this. Oregon is a little bit unique in a couple of its decisions. For example, status as transgender or non-binary is unique to Oregon. Status as a victim of a crime. Other things, you see this pretty common: children's data, precise geolocation. So we're talking about in about a 1,700-foot radius. If you can pinpoint the location of a device or computer, and in combination with an IP address, it's that precise, you would consider that sensitive as opposed to just regular general personal data. And if you want to collect sensitive personal data, Oregon requires that you get explicit consent from Oregon residents who you are collecting from. So sidebar, explicit consent requires action. Inaction can never mean consent. So getting onto a website and filling out a form that might require a personal or a sensitive personal information category, having a privacy policy or terms of use that simply state, by using the website, you consent to giving us this information, is not enough. That is not an action, that is a passive consent, which is okay for other types of data, not okay for sensitive data. So we would want to have some sort of click box, something that we can have engagement with the person and make sure that you're getting explicit consent. Another caveat here is that children's data under 13 always requires consent of legal guardian. You might be familiar with the federal children's privacy regulations. Oregon really is just reiterating those protections in the OCPA. One last comment on here is the mechanism by which you use cannot obscure, subvert, or impair the consumer's decision or usage. So I see this all the time when I go to websites. There'll be some sort of cookie banner that tells me that it's collecting my data, but I can't interact with the website unless I click consent. There's some question around whether or not that's obscuring, subverting, or impairing my use of the website and forcing me into clicking consent, and therefore not actually getting my explicit consent. Something to think about.
Okay, so there's some exemptions to the OCPA, and when we talk about exemptions to the applicability of Oregon's law and actually other privacy laws for that matter, there's 3 different types of exemptions or categories of exemptions. There's data-based exemptions, so certain types of data that you hold are exempted from the reach of the OCPA. Then there's organization-based exemptions, which means that certain organizations are just holistically exempted from the law. And then finally, there's activity-based exemptions. And that means that certain types of activity are not regulated under this law. So this means that a business could have different sets of data, some of which are under the purview of the OCPA and some of which are not. And this could be data about one individual, that some of the data you hold about them is exempted and some of the data you hold about them is governed by the law. So let's go to the first category. I know there's a lot of text on this slide. We're not going to go over all of these, but these are data-based exemptions. So Alex mentioned the two big ones already, which are employment data. So those are people who are in your employ, and business-to-business data. So data about your vendors and other businesses that you interact with. Other exemptions is personal data that's subject to the Graham-Leach-Bliley Act. That's a federal law. Information that's protected under the HIPAA, the Health Insurance Portability and Accountability Act. If that applies to you, you would know that already. A lot of different kinds of patient identifying information that's collected and processed under specific federal laws. Information that identifies consumers, like patient safety work product information that identifies consumers in connection with activities subject to the federal policy for the protection of human subjects. So that's like research information with human subjects that are participating in research, health research, essentially. I will jump to a few other categories. So personal information that is covered by or processed under like the Fair Credit Reporting Act, the Driver's Privacy Protection Act, the Family Educational Rights Act, and the Airline Deregulation Act. So those are very specific federal laws that govern certain types of data. Also exempted is personal data that's processed in the course of like a purely personal or household activity. And then emergency contact information is also exempted. So those are specific types of data exemptions. And then we move on to organization-based exemptions. Again, you would probably know if you were governed by these already, because these were the subject of some lobbying in the legislature before the law passed. So public corporations such as the Oregon State Bar or OHSU, for example, state, local, and special government bodies, financial institutions, which are defined under Oregon law, and their affiliates, but only to the extent directly engaged in financial activities. Insurers and related entities, again, those are defined under specific Oregon laws. Nonprofits that are established to detect and prevent insurance fraud. And entities that provide an information service like a press association or a wire service. So those are organization-based exemptions. And then the last category of exemptions, we'll go to the next slide. Thank you, Alex. Are activity-based exemptions. So activity-based exemptions are non-commercial activities of a publisher, editor, or reporter who's connected to or employed by a newspaper, magazine, etc. Non-commercial activities of a radio or television station. Again, these are stations that hold licenses under the Federal Communications Commission, the FCC. And then other non-commercial activities of nonprofit organizations that provide programming to radio or television networks. So this is sort of think of it as a public television exception. So those are specific activity-based exemptions. All right. I'm going to just jump to a question that we have that goes back a couple of slides. Alex, regarding clicking the cookie bar to accept conditions of use, what's the alternative to get explicit consent, particularly if the business is in a regulated industry?
Particularly if it's a regulated industry?
And I guess I will just jump in and say it depends if your regulation, your industry or the regulated industry might be under one of those exemptions that we just talked about. So that's something that we could look into specifically for your organization. But the other part of the question, Alex, is about clicking the cookie bar to accept conditions of use. What's the alternative to get explicit consent?
Yeah, so the cookie bar in and of itself is not the problem. It's if it's impairing the usage of the website and like forcing the person to click consent to have to like just visit your website and get information. So the cookie bar is not a bad idea. You just have to really think about its functionality and how it's acting with the user experience. Other options is to have, if there's a form, for example, that you're filling out, having a little box at the bottom that says, I have read and understood that I am agreeing to the terms and conditions by submitting this form. I check this box because I know I've read it. The language is flexible. Click boxes are the most common thing that I am seeing. Obviously, if we're not talking in the website zone, you can have privacy notices that get put in front of a person and require a signature.
So
Just remember, oh, go ahead.
No, you go ahead, Alex, that's fine.
Just remember this is about sensitive personal data. So this is only in the case that you want to collect something sensitive. So usually a general website visitor, you're not going to be collecting sensitive data unless you're pinpointing their geolocation to that 1,700 feet or less radius. Or if they're filling out some kind of form where you're asking for, really, really sensitive information like social security number, things like that.
Yeah, that's exactly what I was going to say, that that additional level of opt-in, like affirmative consent, is only required for those certain types of sensitive data. So if you think about if you have a smartphone, when you want to turn on the Face ID or the fingerprint ID in order to log into the app for your bank, it always asks you, do you agree with Face ID for this app? And it requires you to affirmatively say yes, because that type of like your image of your face or your fingerprint is sensitive data. And so they're getting a heightened level of consent from you in order to be able to use that to access their app because it's data that they're then storing. So it's that additional step when it's something of particular sensitivity. Okay, so moving on, the OCPA gives consumers very particular rights, and these are similar to the rights given in many other privacy laws. So you may have been hearing some of these already. So the key consumer rights are the right of access, so to know what data you're collecting, the right of correction to correct inaccuracies in the data, the right of deletion. So that's to delete the data that you have unless you have an expressly permitted reason to keep it. So for example, a consumer can ask you to delete their data, but you're not required to delete it until you've fulfilled whatever transaction you have with that consumer, right? You have to have their address in order to deliver the product that they bought from you, for example. The right to opt out, which is the consumer's right to opt out of the ways in which you use their data. And this includes things such as using data for purposes of targeted advertising, disclosing the data to another party, selling the data for compensation. And then the last consumer right is the right to data portability. And that is essentially the right to get the data from you in a way that they can read and understand it, or they can send it forward if they want to. These rights are designed to ensure transparency, control, and accountability in the handling of personal data. And this is sort of the core of these comprehensive consumer privacy laws, is these consumer rights, right? Privacy laws as a whole are all consumer rights statutes. And so this is where we're seeing like what each of individual consumer has a right to their data and what you do with it.
So the important stuff, how to comply with the OCPA. So this is if you have met that threshold, you're collecting 100,000 Oregon residents data or storing such data in a year, or you are selling and making, a certain amount of revenue, and you don't meet a activity based, data-based, or organization-based exemption. So now we're under the purview where the OCP applies to you. What do we do? The basic obligations, and I'm going to kind of go in order of priority here, is disclose, disclose, disclose. As Parna mentioned, this is a transparency statute. This is all about giving consumers the information. So disclosing what data you're collecting, what you're using it for, who you're giving it to. This is all done usually by a privacy policy or privacy statement. Otherwise, in some sort of document that gets in front of the consumers telling them everything that they are entitled to know under the statute. And then also getting consent, if explicit consent, if required, based on the type of data you want to collect. And then you've got to meet those disclosures. You've got to do what you say you're going to do in your disclosure statements to consumers. And it needs to be accurate, and basically, if you say you're going to use data for a purpose, your actual use of that must be adequate, relevant, and necessary to that purpose. States are particularly sensitive to kind of wordsmithing and playing. Well, we told you we could use it for any purpose, so now we're using it and selling it. That doesn't fly. You need to say you're selling it and what you're doing with the data. You need to meet consumer rights requests. So when a request comes in, you'll need to have some sort of internal mechanism or process in place to respond to those requests. There are reasons why you are allowed to say no to consumer requests, but the point is you need to respond. And another obligation is to trickle down some of these obligations to your third parties and service providers, vendors that are also interacting with the data. So if you say, I will not use the data to target you in advertising, that needs to be true for anyone that you're handing the data off to assist you. So you would want to have a contractual, provision in place that limits that service provider from being able to do the things that you've promised the consumer that you are not engaging in. And I just want to briefly mention that in the coming years, Oregon, like several other states, are going to be looking at implementing a universal opt-out mechanism, which essentially means the state is going to provide some sort of process for consumers to just go there, say, we want all our information deleted from everybody that's doing this thing with data, and you have to respond to those lists, kind of like the do not mail sort of registry. But nothing is implemented there yet, and it's just a very simple warning that it's coming starting January 1st, 2026, and we'll have more details coming over time. So there are permitted uses of data, and then when you have a consumer's right request that you are allowed to use the data as such, you are allowed to respond with, I'm using your data as permitted under the regulation, and this might be one of the reasons why. For example, engaging in a legal claim, fulfilling the product or service request with that person. Like Parna said about, you need their address to send them what they purchased. So you can't delete their information until after that transaction has ended. And there might be a warranty period. There might be a reason why that extends a little bit past the point of receiving the package. You're also allowed to use it for internal research and development. And to perform internal operations, so long as those operations are based on reasonable consumer expectations. So if you're just a company that is selling products online, you're an e-commerce platform, it's completely reasonable that you are going to enlist somebody to help with your payment transactions and maybe your shipping. But it would be kind of off base if all of a sudden you started like calling or a third party started calling consumers to market their own products because you've given their data onward to a third party. That's kind of, that's going to be outside this realm of what you think is like a reasonable internal operation, because that's stepping into, oh, now you're sending my data onward for other purposes that aren't just to do what you and I are in a relationship to do. And then lastly, obviously to comply with, government law, um, and respond to security incidents, identity theft, things like that. That's all going to be a permitted use of data. I want to bring up this idea of controller versus processor. You see this in a lot of consumer privacy laws and other international laws. It's this idea that there's, a party or parties that control and determine the means and methods and whys behind processing personal data. And then you have processors who don't have any control or decision-making power. They're just doing what they're instructed to do with the data. There it can be more than one controller. There can be co-controllers. There can be, there's no limit to how many people could be determined to be a controller. So if you have any power as a business to determine the purpose and use of data that's under the statute, you should pay attention to controller obligations. And anytime a controller is mentioned, they have more, just a little bit different of a role in their obligations than processors, because processors don't have that control and ability to change the way that the data is used. They're operating under someone else's instructions. So controller responsibilities.
I'm gonna just jump in really
Yeah.
quick. And say that one business could be a controller as to some data and a processor as to other data. So it depends what your business is and what data you have, but it's possible that in like one contractual relationship, you're a controller, and in another contractual relationship with another vendor, you're a processor. So just keep that in mind, that your role may be different depending on your particular circumstance.
Yeah, that's a great point, Parna. And it reminds me to bring up, we want to look at your data sets, as data sets, just for the same reason of applying the exemptions. One particular set of data might not fall under the purview of this, and one particular set of data might. So it's all about kind of understanding those different sets and what's going on. So where you discover that you are a controller of data, you are the primary responsible party for responding to consumer rights requests. You need to establish specific data processing provisions with any of your third-party service provider vendors, anyone that's touching the data that you are controlling and they are going to process for you for some reason. There are specific administrative, organizational, and physical safeguards. I put the law up here that has the list of like the technical. This is for your IT team to make sure that they're meeting the latest security requirements under state law. And then, if applicable, and Parna will talk about what these are, you'll need to conduct a data protection assessment. If you are a processor, you're equally responsible in a lot of ways, but you do have a different role in how you have to support a controller. For example, it is the controller's primary responsibility to respond to consumer requests, but they might need to pull in a processor. For example, if I say I would like my data deleted from such and such corporation, and corporation is handing my data off to 5 third-party vendors for purposes, for whatever purposes, they're going to then have to trickle down that request to the processors and tell the processors to delete it as well. So it's the processor's responsibility to work with and cooperate with the controller to meet those consumer rights requests. They also need to delete data when they're instructed to. And then lastly, processing the data solely in accordance with what they the contract says they can do with it. So if the contract does not allow for marketing, you should not be marketing as a processor to a controller's set of consumers, even though you have access to that data. Okay, so this is a list of contractual obligations. I won't go through this in too much detail. The main point is both parties need to be identified as processor or controller, the obligations and the responsibilities. I really recommend having some sort of process in place for consumer rights requests addressed in a contract so that everyone knows what's going to happen when something comes in. You've got to identify the nature and purpose of the data, what the data processing activities are going to be, what limitations the processor is under. They're not allowed to market. It should say you're not allowed to use it for anything other than ... This is what we'll use it for. And then you also want to require your third-party vendors to trickle down those obligations if they're pulling in anybody else. So it's kind of this domino effect. Everyone needs to trickle down and be required to obligate their own service providers to the same standards. And then lastly, retention. You also want to talk about in this contract how long the processor is allowed to retain the data for. Is it just to provide the service? So if it's a transaction processor, just to process a transaction and then they delete it after, or what is that going to look like for you?
Okay, so let's talk a little bit about data protection assessments. So the Oregon Consumer Privacy Act's data protection assessment requirements are, for reference, similar to a few other states, including Connecticut and Colorado. The OCPA states that a controller, so again, this is just the controller of data, must conduct and document a data protection assessment for each of the controller's processing activities that presents a, quote, heightened risk of harm to a consumer, including, for example, processing personal data for the purposes of targeted advertising. This is if you are in if you have an e-commerce business, this is very common. So if you have any sort of targeted advertising and you're processing personal data for that reason, you're going to need to conduct a data protection assessment. If you're processing any sensitive data, if you're selling personal data, and I just want to spend a second to talk about selling. Selling in the common understanding is you're giving someone something for money. However, selling can also be that you're giving someone a data set in exchange for better contract terms or in exchange for a different rate on your contract. So if you're giving
other data,
yeah, you're trading for other data, that's selling under not just Oregon, but a number of states' privacy laws. So if you're getting any sort of value in exchange for giving another party data, then you fall under the category of selling. And so this can even be, we have to look at your vendor contracts for things like you're allowing the vendor to, if you have a vendor that provides some functionality on your website, and you're allowing the vendor to use your data, not just to provide that functionality, but also to better their product. They're combining it with the data of all of their other customers and they're making their product better, and it's not in a de-identified way. You may be selling data under that arrangement. And so those are things that you need to consider and look more deeply into the provisions of the law to see if that counts as selling. In any event, so moving back to data protection assessments, if you are using personal data for purposes of profiling, and if the profiling presents a reasonably foreseeable risk of unfair or deceptive treatment or unlawful disparate impact on consumers, if there's a risk of financial, physical, or reputational injury to consumers, other physical or other types of intrusion upon a consumer's solitude or public affairs, if the intrusion would be offensive to a reasonable person, or other substantial injury to consumers. So again, those are all in the category of profiling consumers in some way. So any of those types of activities are considered creating or presenting a heightened risk of harm to consumers, and that's when you're required to conduct a data protection assessment. Another notable requirement introduced by the OCPA is the recognition of universal opt-out mechanisms by data controllers. And again, this starts January 1st of 26. So just to level set, you all may be familiar where you have a browser on your computer like Google Chrome or Microsoft Edge. And one of the options in your browser settings is that you want to opt out of allowing websites to collect your data. Most websites ignore those signals that they get from browsers. And most privacy policies, I shouldn't say most, many privacy policies incorrectly state that the website does recognize those opt-out mechanisms, even if it doesn't. So the Oregon law starting January 1st, 2026 requires businesses to honor those universal browser and device mechanisms. So if a browser on a phone or on a computer is sending a message that the person using that browser or the device using that browser has opted out, starting January 1, 2026, your website is going to have to honor those mechanisms. And as Alex said, there's a consideration of some other opt-out list that is that may come about, but this is what's currently in the law, is honoring those universal opt-out mechanisms that are from browsers and other devices. So as long as it's commercially feasible, that technology has to be honored. Again, you have more time on that, but that's another website functionality that you're going to need to address. Okay, so the right to cure and non-compliance. So the Oregon Attorney General is responsible for enforcing the OCPA. The Attorney General can serve a demand to anyone who possesses, controls, or stores information relevant to an investigation. If there is a violation, the Attorney General will send a notice, and there's a 30-day cure period to correct the violation after receiving the notice. And then failure to follow through within that time frame could lead to additional action without further notice. This notice and cure process only extends to January 1st, 2026. So it's sort of a buffer from no privacy law to having a privacy law in the state. It's a little bit of time to give people or to give businesses an opportunity to sort of get their processes up and running if they get a notice of violation. Entities that violate the OCPA, the fines that are in the statute are up to $7,500 per violation. Obviously, enforcement has not started yet, and we haven't seen what this is going to look like. But in my view, per violation is likely to be per consumer's rights that are violated. And attorney's fees can also be awarded on either side, so to the Attorney General or to the company defending an assertion of violation if there was no objectively reasonable basis for the Attorney General's claim. There is a 5-year statute of limitations on any penalties, which means that the penalties only have sort of a look back period of 5 years. And again, that's from the, I believe, Alex, you can correct me if I'm wrong, that's only to the date that the law was in place. So they're not going to be looking at violations that predate the law being effective. An important thing to note is that consumers do not have a private right of action, so you cannot be sued by an individual consumer in Oregon. I will say that there are very creative lawyers out there that may find a way to bring a cause of action under this law via some other law. We're seeing just beginning to see a little bit of that in California under California's law, which has been in place since I think it was 2020 that went into effect, maybe 2021. So we are seeing some sort of creative lawyering on the plaintiff side, but right now there's no consumer private right of action. Okay, so we have just about 10 minutes left. Just a few steps to think about for your business in terms of action items. So assess your data collection practices. What data do you have? And where is it being disclosed? Who are you disclosing it to and why? This is really something to think about company-wide. Obviously marketing folks, but also other parts of the business may be holding data sets and really thinking about what you have, why you have it, do you really need it? I like to joke that in sort of the marketing world, more data, they always want more data, sort of more data is better. But that becomes more potential liability and more potential, it brings you closer to that threshold number of Oregon residents that you're holding data for. So what do you have, why do you have it, and who are you giving it to? How is it being disclosed? The next action item is updating any privacy policies and notices, making sure they're current, making sure they accurately reflect what data you have, what you're doing with it. If you have if you discover that you're collecting this sensitive personal data when you do that assessment, ensuring that you have a consent mechanism in place. As Alex mentioned earlier, there's all of the consumer rights that you're going to get requests for. So making sure that you also have procedures in place, both the technical procedures as well as the internal procedures to respond to those consumer requests. And then finally, reviewing your third-party contracts to make sure that your vendors are obligated to cooperate with you to the extent they're processors of your data, and making sure what they do with the data is limited. And then if you're a controller, considering if you fall into any of those categories that require you to conduct a data protection assessment. We're happy to help with any of those things. We can help you assess if the law is applicable to you. We have a questionnaire that we can provide to start with your internal data assessment process. Obviously, drafting and revising disclosures, reviewing contracts, and then advising on data collection processes. So are there any, I just want to make sure, give people a moment if there's any questions. I don't see any in the Q&A. I know we're closing in on our time. So I will just give it back to Alex to talk briefly about the data broker law.
Yeah, so the data broker law we're talking about because it's already in effect and it applies if you are selling. Keep in mind that selling is pretty expansively defined. If you are selling data, there is a registration requirement with the state. Essentially what there is there's a website hosted through the Consumer and Business Services that lists companies that are selling data of Oregon residents, and it provides us as consumers the right to go to that website, click, I want to be removed from all of these, and the state then sends a notice to everyone that's registered, and you have 45 days to scrub and remove that person's data and not sell that person's data going forward. It's a pretty easy registration process, $600 filing fee. The onus really is on having an internal process in place to delete someone's data who you get the notification. It's a 45-day window. And there's also another obligation that you have to report any sort of security breach to the state of Oregon, which is covered under other laws, but this is another reason and another way to enforce security breach notification.
And this law applies to personal data that you obtain not directly from the consumer themselves. So if you obtain a list of consumer information or a list of people, a list of data from a third party, and then you are taking that list and selling it or licensing it or giving it to someone else, that's the activity that this law is intended to govern. Even if it's not the whole of your business, sort of buying lists and selling lists, if you're doing it even minimally, the data broker law is going to apply to you. And there are two other states that also, three other states. Which states are those, Alex? Do you remember?
It's Texas, Vermont, and California.
That also have these data broker laws, and the registration requirements are similar. So if you're engaging in that activity, this is a new sort of field of laws that are going to be applicable to you.